case for him.
Oh, I'm sorry. Yeah, this is my mistake. Yeah, so we are here on a violation of probation.
Correct. And Your Honor, I was able to speak with Agent Holly with regards to the underlying violation. She is agreeable if the court is to dismissing this probation violation. The underlying charge has been dismissed. He's doing well on probation. He continues to make payments towards his arrears.
All right, Ms. Brenner, do the people have any position on that?
Your Honor, he's actually not making payments towards his arrears. He is making payments through the system. However, none of it is making it to this case. So there have been no payments towards this case since December, because what he pays in first goes towards a current active case and nothing is making it towards this case. So if he wants it to be applied to this case, he'll have to pay it directly at the front of the court and ask for them to do it by special instruction. So he doesn't have a large balance left on this. It's mostly state owed fees, but it's $4,477.57. So he does need to take action to make sure that there is something going towards this. But otherwise, if Agent Holly is okay with dismissing the violation, I'm okay with it as well.
What does he owe again? I'm sorry. What was the
$4,477.57.
Okay, thank you.
Yeah.
Yeah, the domestic was dismissed. Apparently the mother of these children, he has a no contact order and she was there to pick up the kids.
Okay. All right, if the underlying charges have been dismissed and the probation officer is requesting or in agreement with dismissal, then the court will dismiss this probation violation. There is still the somewhat separate issue of payments being made toward this case, which obviously needs to happen. If that doesn't happen, that would be a separate probation violation. So Mr. Perez, you need to make sure that you're making payments on this case as well.
Okay. I thought it was coming out my check already.
So
there are payments coming out of your check. Yeah. I'm sorry, Judge. I'm sorry to interrupt.
So the payments that come out of your check only get applied to active cases. So cases where you have a current monthly child support charge.
Okay.
This case doesn't have a monthly charge, so none of that gets taken out of your check gets applied to this case. So you need to make a separate payment. You would need to come in directly to the friend of the court and make a payment in person so that they can apply it to this case, because anything getting taken out is not getting applied to this case.
Okay, no problem.
All right, so you are all set for today. Mr. Perez, you can go ahead and log out.
All right, thank you.
Thank you. Thank you, Ms. Brenner.
Thank you, Your Honor. Thanks, Agent Holly.
Okay, Ms. Underwood, you have Mr. Bowen.
I do, Your Honor.
Do you need a breakout session with him?
I do not.
Oh, Jim. Here. This is file 24-21987-FH, People of the State of Michigan versus Daniel Don Bowen. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Ron Underwood for Mr. Bowen this morning, Your Honor.
And Ms. Underwood, where do we stand with Mr. Bowen's case today?
I've discussed this matter both with Ms. Brunner and with Mr. Bowen, Your Honor. And Mr. Bowen is making payments, doing well. He did have a medical issue last week, but he's back on track. And we would ask for an adjournment in this matter for some probably 60, 90 days, Your Honor. And I would be
Ms.
happy
Brenner?
to do the stip an adjournment.
He's doing really well, Your Honor. He's making great payments. He's got a really high arrearage, but he's chipping away at it. It's an all arrearage case at this time. So I have no objection to the adjournment. The hopes are to just keep him chipping away, and ultimately we'll probably end up with a delay plea on this.
Okay, Sergio, I forgot to grab the folder, the red one. Get that from Francis. All right, let's go with August 13th at 8:15 a.m. then, if that date works for everyone.
Yes, Your Honor. Thank you.
Thank you, Your Honor. And I will do the stip and adjournment with Ms. Brunner's permission.
Thank you, Rhonda.
Thank you, Your Honor.
Okay, thank you. So Mr. Bowen, your next date is August 13th at 8:15 a.m.
Okay, thank you, sir. Am I free to get off, Your Honor?
Yes, you can go ahead and log out.
Have a blessed day.
Ms. Underwood, I have Mr. Simmons here in the courtroom. Do you need to speak to him?
I believe that's a show cause, Your Honor. I don't know.
Oh, okay. Sir Simmons, you want to come forward to the podium, please? This is file 22-21164-FH. People versus Lamont Simmons. We are here today for a hearing on a request and summons for probation violation. Sir, you are Lamont Simmons?
Yes.
Mr. Simmons, have you received a copy of the request and summons for probation violation?
Yes.
That alleges that you violated the terms of your probation by failing to complete the domestic violence alternative program as previously ordered by the court. You had, in this case, previously pled guilty to domestic violence second degree. And the maximum possible penalty for that offense up to 93 days in jail and or a $500 fine. Do you understand that?
I don't know. They just called for you. They assume they're ready for you.
I'm sorry, do you understand that, sir? You do have the right to be represented by an attorney here today and at any other proceedings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
I'd like to have.
I'm sorry?
I'd like to have a.
Okay. Do you have the ability to pay for your own attorney?
I know. Sorry.
All right. So I'll appoint the public defender's office to represent you. If you'll step outside to the hallway, right to your left will be an iPad that's on a stand. And I will put you in a breakout session with Ms. Underwood from the public defender's office. All right, Mr. Dagger, Margosian, do you need to speak to Mr. Cole?
Yes, please, Your Honor.
Okay, Mr. Cole, can you hear me?
Sorry, I can't hear anything. Can't hear anything.
Okay, 1 second. Can you hold Jim? There's something wrong with his. Maybe. All right, Mr. Simmons, if you give me just a second, I'm going to put you in a breakout session.
Okay.
Can't hear anything.
That's fine.
Not really. I mean.
I know, I'm working on it.
Are you able to hear me now, Mr. Cole?
See, the sound's coming from on top of the booth, outside of the booth. I need it inside here where I can hear.
37, when available, can we get a spray bottle to 2 blocks?
Clear. Stand by.
Got you.
All right, Mr. Cole, can you hear me now?
Yes, sir.
Okay, I'm going to put you in a breakout session with your attorney if you give me just a moment.
Okay.
Okay, Ms. Aycock, is that Mr. Forbes Lovett with you there, I presume?
Good morning, Your Honor. Yes, this is the defendant, Mr. Forbes Lovett, present to my right.
Good morning, Your Honor.
This is file 25-22219-FH, People of the State of Michigan versus Jacob Valentino Forbes Lovett. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Good morning, Your Honor. Phoebe McClure, on behalf of the people.
Good morning, Your Honor. Leslie Aycock, on behalf of the defendant, who's present to my right. Can you please state your name for the court on the record this morning?
Jacob Forbes Lovett.
Okay, and Ms. Aycock, where do we stand with this case today?
Your Honor, I've had continuing discussions with Ms. McClure, and we are continuing to negotiate this. We would ask for perhaps a couple-week adjournment. We feel that, I believe that we can resolve the matter in that time.
Ms. McClure, is there anything we need to address from the people's side today?
No, no objection.
So I will adjourn this then to July 9th at 8:15 a.m. This was bound over back in April, so we're getting to the point where if we don't have a resolution at the next pretrial, I would be giving it a trial date.
Very
So,
well.
Your Honor, part of the resolution is that Mr. Forbes Lovett is to complete a defensive driving program. And I believe it'll be online. I'm wondering with the holiday if July 9th is going to be enough time for the defendant to complete that. If he thinks it is, then that's fine. I just wanted to make sure, because I don't want to have to adjourn it again.
I guess for me to address it, I wouldn't be 100% sure if it would be possible maybe to go out an additional week. That would perhaps be helpful. I appreciate that suggestion, Ms. McClure.
Yeah, we can do that. That would be let's see, the next week would be July 16th.
And then just as soon as that's completed, just provide proof to my office. I think you have my email address now.
Correct. I certainly will. I'll hope to get that to you well prior to the court date.
Okay, Ms. Aycock, then would you do a stipulation in order for that adjournment to July 16th at 8:15?
Yes, I will get that to Ms. McClure for signature and then to the court thereafter.
Okay.
Thank you.
All right, thank you for your time. Then you can go ahead and log out.
Thank you. Have a good day out.
Okay, Mr. Glazier, are you going to need a breakout session with Mr. Stover? You're muted, Mr. Glazier.
Yes, Your Honor.
Let me. Mr. Stover, I'm going to put you in a breakout session with Mr. Glazier if you give me just a moment.
All right, thank you kindly.
Okay, Mr. Simmons, you can come back forward to the podium, please. All right, we are back on the record in People of the State of Michigan versus Lamont Simmons. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Simmons this morning, Your Honor. Thank you.
And you know how Mr. Simmons wants to proceed today?
At this time, we would ask the court to enter a not guilty plea on Mr. Simmons' behalf, Your Honor, and set this for a pretrial about a month to 6 weeks from now, Your Honor, given Mr. Simmons time to complete some things for the probation department that we would like done. And he understands the importance of doing that. So if we could have an adjournment, Your Honor, that would be very helpful.
I'll enter a not guilty plea for Mr. Simmons. I'll set this for a pretrial on August 6th at 8:15 a.m.
Thank you, Your Honor.
So Mr. Simmons, your next date is August 6th at 8:15. Thank you. Mr. Murphy, I have Mr. Stepanski is here in the courtroom. Do you need to speak to him?
Probably just briefly, Your Honor. I spoke with him yesterday. I think by just a minute.
All right, Mr. Stepanski, if you want to step outside to the iPad, I'll set you up for the breakout. Okay. Ms. Underwood, do you need to speak to Mr. Keir?
I don't, Your Honor. Thank you.
Okay. Okay, Mr. Stefanski, just 1 second here.
Yes, sir.
Judge, something took me out of the room with Mr. Stover.
Sorry, I'll put you back in that then. Okay, and Mr. Dagger Margosian, are you ready to proceed with Mr. Cole?
Yes, Your Honor.
This is file 25-22296-FH. People of State of Michigan versus Michael Patrick Cole. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed for the people.
Good morning, Your Honor. Isaac Sneed on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Cole.
And Mr. Dagger Margosian, does Mr. Cole wish to have the information read today?
No, thank you.
Have you received copies of the prosecutor's witness list and request for discovery?
Yes.
And how does Mr. Cole wish to proceed today?
Your Honor, for arraignment purposes, it would be not guilty, but we do have a resolution that we can enter today.
Okay, and what is that resolution?
Mr. Cole will be pleading guilty to a DV second with a sentence agreement for a 6-month jail cap. And in exchange for that, the original information would be dismissed.
Mr. Sneed, is that a complete and accurate statement of the agreement?
That is accurate, Your Honor. And in our office, if the court hasn't received it yet, we'll be submitting an amended information adding a count 2 domestic violence second offense. In addition, there was one other term that the defendant would have no contact with a Regina or a Gabriella Wandel.
Is that accurate, Mr. Dagger Margosian?
Yes, Your Honor.
All right, I'm going to pass this for a minute, and then when we have that amended information, we'll continue.
Thank you, Your Honor.
Here next. This is file 25-22274-FH, People versus Timothy Allen Keir. We are here today for a pretrial conference in this case. There's also a pending contempt from district court. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may I have the people?
Ron Downwood on behalf of Mr. Keir, Your Honor.
And Ms. Underwood, where do we stand with Mr. Keir's case today?
The first thing we'd like to do, Your Honor, is Mr. Keir would like to plead guilty to the contempt, Your Honor, from district court.
All right, Mr. Keir, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Timothy Allen Keir, is that correct?
Yes, Your Honor.
Mr. Keir, do you understand that the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500?
What was that?
Do you understand that the maximum possible penalty for a contempt of court is up to 93
yes, Your
days
Honor.
in jail or $7,500 in fines?
Yes, Your Honor.
You can put your hand down if you like. Do you understand that you have a right to contest the contempt of court charge and have a trial?
Yes, Your Honor.
Do you understand that throughout the trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes, Your Honor.
You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you'd have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, Your Honor.
How do you plead to the charge that you committed contempt of court by violating your bond conditions?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, so you were on bond at one point in this case while it was in district court, and you had various conditions of your bond. Is that correct?
Yes, Your Honor.
All right, and what did you do that violated your bond conditions?
I failed to call to drug test.
Okay, so you had drug testing conditions
Yes.
and you missed a test?
Yes.
All right. I will accept a plea. It's been given understandably, voluntarily, and accurately. Mr. Kier has had full knowledge of his rights, and he has had competent counsel. Before the court passes sentence, Ms. Underwood, anything you want to say on behalf of Mr. Kier?
Just that Mr. Kier has been in jail on this since May 8th, Your Honor. Mr. Kier doesn't have any funding, Your Honor. I think the court has already found that before. We would ask for time served. We believe that's appropriate.
Mr. Kier, is there anything you'd like to say on your own behalf at this point?
I'm homeless. I got my grandpa's address. That's where I would go if I make it out of here.
All right, it will be the sentence of the court that Mr. Kier served 60 days in the Lenawee County Jail. He does have credit for 48 days served. Mr. Kier, when you're released, you need to come over to the courthouse and report to Darren Coast as soon as the day that you get out. And if it's after about 4 o'clock that you're released, you need to come the very next day.
Yes, Your Honor.
And I'm going to put you in a breakout session with Mr. Coast so that he can collect some information from you.
Do we want to do his underlying pretrial first?
Oh, yeah, I'm sorry. Thank you, Ms. McClure. So Ms. Underwood, where do we stand with respect to the underlying case?
Your Honor, there was a preliminary examination, so we need a transcript for that. And probably a pretrial with an appropriate date, Your Honor.
All right, has the preliminary exam transcript been ordered yet?
I don't
This
believe
is
so.
the first, this is the first pretrial after arraignment, so I doubt it.
All right. So I'll enter an order for the preliminary exam transcript, and We'll set this for pretrial on August 13th at 8:15 a.m.
And Your Honor, just given Mr. Keir's failure to appear history as well as his failure to comply with bond conditions, I just ask that a bond remain in place.
Your Honor, I believe the bond is PR, and that's why he's going to see Mr. Coast when he gets out.
Well, then I would ask that it be raised from a PR.
Your
Judge,
Honor, that would be highly inappropriate in this case.
Judge, it was my understanding the bond was $10,000. A pretrial assessment was done on Mr. Keir back on June 2nd.
Bond on the contempt of court was $10,000 cash or surety. The bond on the underlying charge is a $5,000 personal recognizance fund.
Okay.
That's what happened at bind over. I don't know what conditions are on that bond, but I would include, if they're not there already, that Mr. Keir report to Mr. Coast, as directed by Mr. Coast, that he not use alcohol, marijuana, or any illegal controlled substances, that he participate in a drug testing and monitoring program.
Thank you, Your Honor.
And that he abide by a curfew of 8 p.m. to 7 a.m.
Thank you, Your Honor.
Ms. Underwood, would you do a stipulation and order on the pretrial?
I would be more than happy to do that. What's the date again, Your Honor?
August 13th.
Thank you, Your Honor. With Ms.
Thank you,
McClure.
Mr. Keir. You can let the officer with you know that you're done with court for today. Okay, I have the amended information on Mr. Cole now, so we can proceed with that. Back on the record in file 25-22296-FH, People of the State of Michigan versus Michael Patrick Cole. I do have that amended information at this point. Mr. Cole, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Michael Patrick Cole?
Yes.
Mr. Cole, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, domestic violence, second offense?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record this morning. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Cole?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cole, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
Just got some paperwork for you, so.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about June 8, 2025, in the city of Adrian, County of Lenawee, that you did commit the offense of domestic violence, second offense?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cole to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Cole, other than as we've discussed it on the record this morning, has your attorney promised you any particular sentence or estimated what it would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Mr. Dagger Margosian, do you want to cover the factual basis?
Mr. Cole, on June 8th of this year, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes.
On that date, did you have a physical altercation with Gabriella Wandel?
Yes.
Did you push her to the ground?
Yes.
And you didn't have consent to do that?
No.
All right. And you have a prior conviction for domestic violence 2024?
Yes.
Okay. I think I'm satisfied.
Mr. Sneed, are the people satisfied with the factual basis?
Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Cole has had full knowledge of his rights and has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the district court probation office for a pre-sentence investigation and set sentencing for July 24th at 8:15 a.m. Mr. Cole, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
You can let the officer with you know that you're done with court for today, Mr. Cole.
Thank you.
They're the ones you can just slip your foot in, you don't have to.
All right, Mr. Glazier, are you ready to proceed with Mr. Stover?
I am, Your Honor.
Yes.
This is file 21.
Because it's scheduled six or business. But they should have.
This is file 21-20605-FC, People of State of Michigan versus John Mitchell Stover. We are here today for a hearing on an alleged violation of probation, and we are proceeding today by video conference. Mr. Glazier, do you want to place your appearance on the record?
John Glazier on behalf of Mr. Stover.
And you know how Mr. Stover would like to proceed today.
Your Honor, this is one where they had one petition and then they withdrew it and they issued a second one. I think we would want to resolve it. We was wondering if he could get a Cobb's agreement on a sentence. He's in prison right now.
Okay.
He's in prison on the fleeing and looting that's referred to in the new
Okay.
petition.
So I'm just looking back to refresh my memory on the original sentence to see whether it had a suspended sentence of any kind in it.
I don't know. He said he did a year in jail on it.
I do recall that. I don't recall, Ms. Holly, do you know what the original sentencing guidelines were in the case? It seems to me we sentenced below guidelines in this.
Yes,
Never mind.
43 to 95. I originally recommended 5 to 10. There was an agreement to no more than 1 year jail.
All right, given my current recollection of the case, I would in terms of a Cobb's evaluation, say that the recommendation is probably appropriate given my recollection of the circumstances, and so that's where I would be in terms of a Cobb's evaluation.
Which would be what, 43?
No, 60.
That'd be 6 minutes. Okay, I'll need to speak with my client, Your Honor.
Okay, Ms. Dumont, are you still there?
I'm here, Your Honor.
Okay, do you need to speak to Mr. Lake?
No, Your Honor.
Right. This is file 25-22255-FH People versus Richard Lewis Lake. We are here today for a pretrial hearing and proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Katerina Dumont, attorney for Mr. Lake.
All right, and sir, you are Richard Lewis Lake?
Yes, sir.
Mr. Lake, we treat appearances by Zoom just as if you were in the courtroom in person, so I need you to remove your hat, please.
Oh, yes, sir.
Ms. Dumont, where do we stand with Mr. Lake's case today?
Your Honor, I spoke with Ms. Brenner. She and I are both agreeable to an adjournment. In this case, what we would be asking for is a 60 to 90 day adjournment. His current monthly payment is $431. He did indicate to me that he is able to pay $200 a week now that his work is picking up. I did get employment verification from him as well.
Okay, Ms. Brenner.
I don't have any objection to that, Your Honor.
All right. Let's set it then for August 13th at 8:15 a.m.
Thank you, Your Honor. Ms. Dumont, are you going to prepare that?
Yep, I'll prepare step in order.
Thank you. Have a nice day.
Mr. Lake. Mr. Lake,
Yes,
the next
sir.
date is August 13th at 8:15.
Absolutely.
So you're all set. You can go ahead and log out.
Thank you.
My video sold.
Mr. Murphy, are you ready to proceed with Mr. Stepanski?
Yes, Your Honor.
All right, Mr. Stepanski, you can come forward to the podium. Yes, sir. I'm sorry. We just are printing some documents. Okay, this is file 25-22251-FH, People versus John Robert Stepanski. We are here today for a pretrial hearing as well as a show cause hearing on an alleged bond violation. We are proceeding today partially in person and partially by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Stepanski.
And sir, you are John Robert Stepanski, correct?
Yes, sir.
Mr. Murphy, where do we stand with the case today?
Your Honor, in regards to the underlying charge, I was speaking with Mr. Stepanski out in the hallway. There was a change. There is an agreement by the prosecution that there will be no upfront jail in the matter if he was to plead to count 1, possession of cocaine with no habitual offender status and no supplements. Mr. Stepanski, do you want to accept that plea offer then because there is an agreement for no jail? Yes, sir. So, Your Honor, this time we do want to enter a plea again to count 1 on the information, possession of cocaine, dismissal of count 2, which is the forgery, operating with a license of forgery. We did send over a plea agreement. I don't know if the court's received it yet or not. But in regards to there's a show cause. I don't know if the court wanted to proceed with that now before we take the plea or proceed with that after arraigning him on that.
Let me do that afterward. I don't have in the file for some reason. I'll look that up. Mr. Murphy, do you know how he wants to proceed on the show cause?
Your Honor, I don't know if the court, well, we'll just ask the court to enter not guilty and set it for the sentencing date. And again, I believe that it was, he fell off the wagon, if you want to put it that way. But again, his performance between now and the sentencing date, I think would ask the court just to take that into consideration. But if we could just adjourn that out, enter not guilty plea and set it for whatever the sentencing date would be.
Okay, let me do the plea first then. Mr. Stepanski, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are John Robert Stepanski, correct?
Yes, sir.
Mr. Stepanski, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of cocaine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice he's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Stepanski?
Yes, sir.
If the guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? Yes, sir. You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right? Yes, sir. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights? No, sir. Do you understand that you're giving them up? Yes. How do you wish to plead to the charge that on or about October 11, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of possession of cocaine? Guilty, Your Honor. Has anybody made any threats or promises to you to induce you to plead guilty to that charge? No, sir. Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea? Yes, sir. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Stefanski to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Stefanski, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what it would be? No, sir. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that? Yes, sir. Is it your own choice to plead guilty? Yes, sir. Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Mr. Stefanski, were you indeed in the city of Adrian, county of Lenawee, state of Michigan on October 11th, 2024?
Yes, sir.
And on that date and time, did you have in your possession some cocaine?
Yes, sir.
Did you know that it was cocaine?
Yes, sir.
And would you agree that you had less than 25 grams for personal use?
Yes.
Okay, Your Honor, I believe I established the factual basis.
Mr. Bandetto, are the people satisfied?
The only thing I would add, Mr. Stefanski, you understand you had no legal basis for being able to possess that cocaine, correct?
That's correct, yes.
Yeah, I'm satisfied, Your Honor.
Has the court applied MCR 6.302 B, C, and D, Mr. Bandetto?
It has, Your Honor.
Mr. Murphy?
Yes, Your Honor.
All right, I will accept the plea. It's been given voluntarily, understandingly, and accurately. Mr. Stefanski has had full knowledge of his rights. He has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 25th at 8:15 a.m.
Your Honor,
Mr.
can
Stefanski-
I apologize, Your Honor. When the court feels it's appropriate, can I be heard as to bond? Mr. Coast has made me aware of some things that I think need to be addressed before we break for this case.
So Mr. Stefanski, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background. Yes, sir. We also had the show cause for alleged bond violation. Mr. Stefanski, have you received a copy of that document? Yes, sir. That motion affidavit in order to show cause alleges that you violated your bond conditions by testing positive for cocaine in drug screens collected on May 19th, May 29th, June 2nd, June 10th, and June 11th. And also that you missed your drug tests on May 22nd, May 28th, and June 7th. Do you understand that that's the allegation against
Yes, sir.
You understand that the maximum possible penalty for violating bond conditions is up to 93 days in jail or up to $7,500 in fines.
Yes, sir.
Obviously, you're represented by Mr. Murphy in this case already, and Mr. Murphy has indicated that you want to enter a not guilty plea with respect to that violation. So I will enter a not guilty plea and we'll set that for the date of sentencing, which again was July 25th, 8:15 a.m. Mr. Bayonetto, then what did you want to address regarding bond?
Yes, Your Honor. Speaking with Mr. Coast this morning, I know the court just read off a bunch of positive tests. However, he also has failed to test his last two tests, June 20th and June 23rd. Mr. Murphy, I think, did acknowledge that there is a continuing substance abuse issue here with Mr. Stepanski. I understand the agreement is for no jail in this case. However, I think perhaps a remand into custody while awaiting sentencing is appropriate. And I would ask that the court order that at this time. And hopefully we can get some services in place for Mr. Stepanski before sentencing.
Your Honor, I would ask the court not to, I'm sorry. I would ask the court not to remand Mr. Stepanski. I believe if you would test him today, he would test clean. I spoke with him yesterday. Again, we're not denying that he made flipped up and started using again. I guess at this point, obviously we're not really denying that he's taking responsibility for it. We could continue and enter a guilty plea at this point. I just don't think that incarceration is necessary. He showed up today knowing he had these positive tests. Again, knowing I explained to him yesterday that the court very well could trust him, and I'll probably ask for him to be tested because of this situation, that I don't believe he's a flight risk. I believe the issue may be, again, his use, and services can be provided for him outside of custody. No need to keep him in custody for that. Again, he's not a flight risk. So that's what I asked the court to consider. And I didn't know if the court wanted to process we could do a guilty plea at this time for that charge if Mr. Stepanski wanted to. Again, he takes responsibility for it. He's not trying to deny it, and he is here presenting himself to the court to do with whatever the court wants to do. He'll abide by it. But again, I don't think that it's necessary to keep him in custody.
Judge, in the past 5 weeks, he tested positive for cocaine 5 times. After the show cause was issued, I actually spoke to John by phone, told him do not miss any more drug screens, do not test positive anymore. He followed that up with the 2 missed drug screens on 6/20 and also 6/23. He's actively using.
All right, so since May 16th, there's been 1 negative test and every other test has been either positive or a no-show. That, including a no-show 2 days ago. Mr. Murphy, Mr. Stepanski has his hand raised. He wants to say something. Do you want him to address the court directly?
That'd be fine with myself, Your Honor. You can address the court if he wishes to.
I just wanted to inform you that I did drop clean last night. I was at that test. Also on Friday, I had a clean drop. I was influenced by somebody. I allowed myself to be influenced, and I've since not spending time with that person. I have a good job going for me. They depend on me. I'm doing very well with my relationships, with my family and my daughter, and I just ask that you would please give me one more chance with the bond conditions. I promise I will not be any more mishaps.
All right, Mr. Coast, can you test him right now?
I can judge, he is correct. He did test on 6/24 and that was negative, but yes, I'll do a drug test on him this morning.
All right, if you can do that, I'd like to know the results before I make a decision on how to proceed with bond.
Thank you, Your Honor.
Mr. Stefanski, if you'll just step to the hallway, Mr. Costa will not proceed. Okay, we are back on the record in People versus John Mitchell Stover. Mr. Glade, we've had an opportunity to speak to Mr. Stover. Where do we stand at this point?
Your Honor, Mr. Stover is going to plead to the violation of probation. I would indicate we've had a kind of a lengthy discussion here. He's pretty upset with me, the court, the whole system. And I told him those are kind of, and particularly he says he and Miss Holly, Miss Holly has it out for him and some other. Those are kind of things I told him we can bring up at sentencing. I've told him that you've indicated that you would not exceed 60 months. And that doesn't mean you're going to give him 60 months. Obviously, you can listen to what he's got to say and what I got to say, and you could give him less if you thought it was appropriate. Is that correct, Mr. Stover?
Yes.
Okay, Mr. Stover, then would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do. So help me God.
And you are John Mitchell Stover, correct?
Yes, I am.
Mr. Stover, do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses you have for your defense to appear at your trial. You understand all of that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also have the right to testify if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you violated terms of your probation?
Guilty.
Do you understand that by pleading guilty, you'll be giving up the right to your trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the record on the court in court this morning, or that it was not your own choice to enter the plea.
Yes, I do.
Is it your own choice to plead guilty?
Yes.
So you were placed on probation in this case that included conditions that you not violate any law of any unit of government. Is that correct?
Yes.
And you were placed on probation. I'm sorry?
I was gonna say to my recollection, yes.
Okay. And you were placed on probation back in February of 2022. You agree with that?
Yes.
And the terms of your probation also required you to report to your probation officer as instructed. Is that correct?
Yes.
And it also required you to pay some court costs and supervision fees. Is that correct?
Yes.
And were you convicted on March 31st, 2025 of fleeing and eluding a police officer and assaulting, resisting, obstructing a police officer?
Yes.
And did you fail to report to your probation officer on March 14th or any time after that?
Yes.
And the other allegation is that you have not paid anything toward the supervision fees. Is that correct?
Yes, Your Honor.
All right. I will accept the plea has been given understandably, voluntarily, and accurately. Mr. Stover has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 25th at 8:15 a.m. Mr. Stover, Ms. Holly is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Your Honor, if I may just say that, I appreciate your foresight in this case, and I do appreciate your due diligence to look over it thoughtfully. It's just there's just been a lot of indifferences with Miss Holly. It's nothing disrespectful against her. It's just that I've always been giving her, no matter what circumstances or situations I've been facing with this in any case. And I just would like an honest, thoughtful look at it all, and to understand that I didn't violate parole the last time I was dealing with Miss Holly whatsoever, once, not even once, and successfully got off parole with no violations. It's always been difficult with her personally. I just want that to be understood. I don't know what it is, why she don't like me, but it's just, that's what it is. I don't know. I don't even know her. And I understand.
I understand your position. I'll give you an opportunity to elaborate further on that at the appropriate time at the sentencing hearing.
I do appreciate it, Your Honor. If you would, please, my mom's going through health issues, and I lost my dad in prison last time. It's a real serious fear of mine, and I don't think people understand that. So I apologize.
Okay.
I feel like I get it off my chest.
All right. So that'll be all for today, Mr. Stover. You can let the officer with you know that you're done with court, and we'll have you back for the sentencing hearing on July 25th.
All right. Thank you.
Thank you, Aaron. That's all I have with you this morning.
Thank you, Mr. Glazer. Okay, let's see. We can go back on the record with Mr. Stepanski's case. Mr. Coast, where do we stand with Mr. Stepanski today?
Judge, we did do a urine screen, and the results were positive for cocaine.
All right. So I think it's clear that we have a problem of active use. And I think that it's appropriate at this point to revoke Mr. Stepanski's bond. It's the only way that we can try to get you some help, which is what we're trying to do here. I will, at this point, consistent with Mr. Coast's recommendation, allow Mr. Stepanski to be released to a residential inpatient drug treatment facility. But at this point, the court has to act to, for lack of a better phrase, protect you, Mr. Stepanski, from yourself, and try to get you some help. So that's what I'm in at this point.
Yes.
Yeah, go ahead.
Your Honor, I just tested clean last night. I don't understand what happened, but I can promise you I will not have any more dirties. If you just give me one chance, please. I have a company vehicle outside. They're depending on me to be at work. My daughter's depending on me. If you could please just give me one chance. Please.
I just can't do that in light of the facts that I have in front of me today.
Yes. Also, the bond condition, my parents, they don't have the money to cover that would be revoked. They can't, because that's going to fall back on them. It's not.
So I'm not forfeiting the bond. Okay. So it's not going to be taken from them. I'm just revoking it, meaning that the bond is no longer an option. But again, given the facts that I have in front of me, I feel this is the only option available. And so at this point, I am going to revoke bond and remand Mr. Stepanski to custody. I will provide for his release to a residential inpatient drug treatment facility as soon as that can be arranged, Mr. Coast.
That'll be fine, Judge. I'll actually speak with him this morning, have him sign any necessary releases.
All right.
Thank you, Your Honor.
All right. Good morning, sir. You are Mr. Sosby?
Yes. Good morning.
Okay. Mr. Sosby, have you been assigned an attorney yet? Do you know?
Yes, I actually was able to speak with her and filled out all the paperwork to send to her also. I finished filing out the last paperwork yesterday.
Okay. And what is her name?
Allison Swain.
Okay. She's not logged
Salem.
in.
Yeah, when I was speaking with her, she was saying that she was planning on seeing me on the 7th, and she was going to try to get in this pushed back at least, because she doesn't have none of the paperwork, none of my court works.
Okay, let me just call the case real quick, and we'll make a record of that. You said she's going to see you on July 7th?
7th, yep, that's when she plans on seeing me.
Okay. So this is file 09-14191-FC, People of the State of Michigan versus Marshall Scott Sosby. We are here today for a status conference in this case. We're proceeding today by video conference. Ms. Bruggeman, would you like to place your appearance on the record?
Jennifer Bruggeman on behalf of the people, P66066.
And sir, you are Marshall Scott Sosby, is that correct?
Yes, Your Honor.
And we were just having a discussion, and Mr. Sosby, you had let me know that you have now been assigned an attorney through the State Public Defender's Office. Is that correct?
Yes, Your Honor.
And you are, at the moment, you have a meeting planned with her for July 7th. Is that
Excuse
also
me, Judge.
accurate?
Yes.
There is a Tina from Stato in the waiting room waiting to be let in.
Oh, I'm sorry. Okay. Okay, good morning, Ms. Olson. I understand that you are here on the Sosby case.
That's correct, Your Honor.
Okay, I'm sorry, I did not realize that, and I had just called the case. So let me go ahead and ask you to place your appearance on the record.
Tina Olson from the State Appellate Defender Office, P82299, on behalf of Mr. Sosby. His assigned attorney, Allison Swain, was unable to make the hearing this morning, but she will be handling the matter and filing an appearance.
Okay, and it was my understanding from Mr. Sosby, they have a meeting scheduled for early July. So if I set this for another status conference on July 16th at 8:15, does that work for you or Ms.
That should be fine for myself or Ms. Swain. And just as a way of update, Your Honor, we have Ms. Swain is picking up the file from the prior attorney on Thursday. I understand it's voluminous, so yes, if we could have that status and update you at that time, that would be helpful.
Okay. So we'll set it for a status conference then on July 16th at 8:15 a.m. Is there anything else that we need to address today?
I don't believe so, Your Honor.
Ms. Brugman,
No, Your
anything
Honor.
from the
No, Your Honor. We will prepare the writ.
Okay, thank you very much. All right, I think then we're all set for today, and we'll see you back on July 16th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Okay, thank you, Mr. Sosby. You can let them know that you're done with court for today.
Yeah, thank you. You have a good day.
Ms. Underwood, I have Anthony Moore here.
Yes, Your Honor.
Do you need to speak to him?
I do not need to speak with him.
So, Gianna, yes.
Thank you.
Okay, this is file 20-19796-FH and 20-19849-FH, People versus Anthony Harris Moore. We are here today for a hearing on a probation violation, proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
I had one for Mr. Moore this morning, Your Honor. Your Honor,
Yeah.
I've spoken with Miss Holly, and it's my understanding Mr. Moore is making payments, Your Honor. We would ask the court to set this out for 3-4 weeks, Your Honor, and give Mr. Moore a chance to get this taken care of.
Well,
Okay, so what I'll do is set this for July 23rd at 8:15 in order to give Mr. Moore an opportunity
Thank you,
to
Your
make
Honor.
additional payments. So, Mr. Moore, your next date is July 23rd at 8:15 a.m.
Thank you. We're done?
Yeah,
I
you
think
can go
that's
ahead and
all I
log out.
have, Judge.
Okay,
I
thank
think
you,
that's
Ms.
all
Hall.
I have. That's all I have, I think.
Thank you. Okay, Mr. Monterez, are you ready to proceed with Mr. Merritt?
I am, Your Honor.
Right, he should be joining right now.
Your Honor, do we have Cameron Broughton from the MDOC? And we have,
I think I have any MDOC logged in right now.
and I have Patrick Skinner from the jail, Your Honor.
Okay, yeah, I'm aware. I'm getting through cases as quickly as I can.
Okay. It's okay. I'm sorry.
Do you need, oh, I'm sorry, Mr. Murphy, do you need to speak to Mr. Madison?
Your Honor, do we have the other file up from district court yet? That's the only real question. Because unfortunately, we weren't able to get in last week. I had him in on Monday and waived, and I don't think the file, I went and asked the clerks if they could try to do anything to get it expedited in front of Your Honor by this morning to have them both. But I don't know if that was done yet or not.
Doesn't look like there are any 25 cases for Mr. Madison today that I can see in the computer system.
So we'd have to adjourn it a week.
Can't we just like plead guilty to it if it comes and then like I just want to get sentenced and get up out of here. Sit here.
I can't do that, unfortunately, Mr. Madison. I can't do anything on a case until it's filed in the district court because I don't have jurisdiction until that happens.
Okay. And Miss, I have a question too. Say I'm sentencing when I do take this. Can I get a speedy sentencing on this? Like I just did a PSI maybe like a year and a half ago. Like I don't even care to participate in. I'm gonna get one set number on what I'm going to do. All they have to do is change some things and all that, because I'm trying to just get up out of jail and go start my time, man. I don't want to sit here 2 more months and then have to wait to go. If there's any way I could have a speedy sentencing.
All right, so the court has requirements that I have to comply with in terms of the timeline for sentencing. I will do that and get you on as soon as I can while still meeting those requirements.
Okay.
Thank you, Your Honor.
Okay, so I'll set it over to July 2nd is next week. I would presume it will be here at that time.
Thank you, Your Honor.
And Mr. Murphy, would you do a stip in order for that adjournment?
It will, Your Honor. Thank you.
Okay, so Mr.
Mr. Baronetto is
Madison
okay if I sign with your permission?
Yeah, that's fine. Yeah, that's fine.
It is. Thank you.
Okay. Mr. Madison, we'll see you next week then and get this taken care of.
Okay, thank you.
Thank you, Your Honor.
All right, so. Oh, Mr. Skinner. Mr. Merritt, sorry, I'm gonna do Mr. Merritt next. Mr. Murphy, do you need to speak to Mr. West?
Please, Your Honor, if I could.
Okay, so let me set up that breakout session and then we'll do Mr. Merritt's case. Mr. Merritt, if you are there, I'll need you to turn on your video. Mr. West, I'm going to put you in a breakout session with your attorney.
Yes, sir.
Okay, this is file 25-22173-FH People versus Brian Merritt. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Good morning, Your Honor. Nicholas Monterez on behalf of Brian Merritt, who's present via Zoom this morning.
All right, and Mr. Monterez, where do we stand with Mr. Merritt's case today?
Your Honor, I substituted in for Mr. Mawad about 9 days ago on this matter. I'd reached out to Mr. Sneed, but I understand that he was out of office. He was kind enough and prompt enough to send me an email this morning with people's offer on this matter. I'd like the opportunity to discuss that with Mr. Merritt, as well as the opportunity to see if there's any information I can provide to Mr. Sneed to potentially resolve this matter, or if we end up in a position where we'll need to set for trial. I believe I'll be in the position on a future date after conversation with Mr. Sneed to provide that information to the court, respectfully requesting an adjournment so that we can come back hopefully with resolution or with a plan to go to trial.
Okay, what I'll do is adjourn this then to July 23rd at 8:15. And Mr. Monterez, would you be willing to do a stipulation in order for that adjournment?
I'd be happy to, Your Honor, and Mr. Sneed will get that sent over to you for your approval.
You can sign with my permission, sir.
Even better. Thank you, sir.
Thank you.
All right, Mr. Merritt, your next date then is July 23rd at 8:15 a.m. I'm going to send you a request to unmute and ask that you confirm you heard that. Did you hear that, Mr. Merritt?
Hello. Yeah, I can't hardly hear anybody.
Your next date is July 23rd at 8:15.
Okay.
Okay, so you're all set. You can log out.
All right. Thank you.
Thank you, Your Honor. Thank you, Mr. Sneed.
Okay, Mr. Dagger, Margosian, I have Mr. Paniagua here. Are you going to need a breakout session with him?
No, Your Honor.
Hello. All right, this is file 25-22163-FH, People versus Juan Carlos Paniagua. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Your Honor, Michael Dagger Margosian for Mr. Paniagua.
And Mr. Dagamagosian, where do we stand with Mr. Paniagua's case today?
Your Honor, I've been working with Miss Arnold, seeing if we can resolve this. I believe that there are just a few more conversations that have to be had with people involved with this case before we know what we can do on this. So I guess I would ask the court if we can adjourn this for a short adjournment, 1 to 2 weeks.
All right, Ms. Arnold, anything to address from the people's side?
No, we would agree. We would concur in that request.
Okay, so what I can do next week is July 2nd at 8:15.
That's great.
That's fine. Thank you.
All right, so Mr. Paniagua, your next date is July 2nd at 8:15 a.m.
Thank you, Your Honor.
Thanks, Judge.
Okay, you can go ahead and log out. Oh, I'm sorry, Mr. Dagamagosian, would you do that step in order?
Yes, Your Honor.
And he can sign my name, of course. Thanks.
Okay, sir, you are Dustin Smith. Your device is muted. I'm going to send a request to unmute that.
Yes, Your Honor.
Okay, Mr. Malero, do you need to speak to Mr. Smith?
Yes, I do, Your Honor. I do need to speak with him.
Okay, and Ms. Underwood, are you going to need to speak to Mr. Skinner?
Your Honor.
I'm sorry, I didn't hear you.
No, Your Honor.
Yes.
Oh. Okay.
All right, 1 second.
Thank you, Judge.
You're welcome. And Mr. Murphy, are you ready to proceed with Mr. West?
Yes, Your Honor.
This is file 20-20069-FH and 25-22294-FH, People versus Wendell Charles West. The 20 case is set for a pretrial hearing, and the 25 case is set for arraignment. We are proceeding today by video conference. First, can I ask the attorneys to place their appearance on the record, beginning with, I'm sorry, Mr. West has dropped out of the meeting. But he is back in the waiting room.
Now, Matthew Murphy appearing on behalf of Mr. West.
Hello?
All right, so we have Mr. West back. Mr. Sneed, you want to place your appearance on the record?
Yes, Isaac Sneed for the people.
So Mr. Murphy, where do we stand with Mr. West's case today?
Your Honor, Mr. West has 2 files. One's an older file that he had retained on. In regards to that file, we had asked that to be adjourned for today. For the other file, they had a newer file to be come up from district court. At this point, I'm asking for another pretrial to be set in the matter. There needs to be further discussions, but with the people as well as with probation in regards to sobriety court, and try to figure out ultimately what Mr. West is looking at for his sentence. So at this point, we're just asking for an adjournment. I think it should be resolved by that time. I do know the other file, again, is fairly old. I do apologize, but again, we weren't on that case until recently, so we do ask the court to adjourn it. Would also ask if we could possibly address his GPS tether requirement on his bond.
Okay, Mr. Sneed, anything from the people's side that we need to address?
I have no objection to the adjournment, Your Honor. Thank you.
Oh, yeah, I'm sorry, the 25 file was an arraignment, so Mr. Murphy, does Mr. West wish to have that information read?
No, Your Honor, we acknowledge receipt of the information, the witness list, and the discovery request by the prosecution in this matter. Again, we just ask for a not guilty plea to be entered and set it for a pretrial with the other already up file.
So I'll enter a not guilty plea for Mr. West on the 25 file and set them both for a pretrial conference on July 23rd at 8:15. Mr. Murphy, would you do the stip in order for the 20 file?
Yes, Your Honor.
And
I'm sorry, what was the date, Your Honor? I missed that.
July 23rd.
Thank you.
Oh, we apparently also need fingerprints in the 2025 file, the newer case. So I'm going to sign an order for fingerprints. And you wanted to address bond, Mr. Murphy.
Yes, Your Honor. Mr. West is having I would say, extreme financial difficulty in trying to meet the obligations and getting all of the bond conditions set. I would ask the court to consider removing the necessity for the GPS tether. While I understand the necessity maybe or the thought of needing it before, Mr. West has made all of his court dates since he's been just the recent one. Again, the old file, the 20 file. Obviously, we understand there was missed court dates, and that has left been hanging. But Mr. West knows what ends up ultimately happening if he doesn't appear. The cases never go away. Again, it can be there for 5, 10, 15 years. And so obviously he understands that he needs to appear moving forward. He has shown that he's going to. So I'd ask the court to consider removing the necessity for that GPS tether.
Judge, there is a bond condition where he's to have both GPS tether and also a scram unit. He was actually fitted for both, but while incarcerated, it looked like Jackson PD picked him up on a warrant that they had. So those devices were removed. So I'm not sure if they were ever placed back on him.
I do.
If I recall correctly, he had the scram last week when he was here, and I advised him that he had to get the GPS put back on.
Okay.
So Mr. West, is the GPS back on?
Excuse me, sir. I was telling my lawyer that I had fines and costs last week and all that, and I ran out of money to do all that. I mean, I told him I'd do it now. I had put out 500 some bucks last week.
Yes, Your Honor. Mr. West, last week when we had district court, he had paid off an outstanding balance. He had, again, $500 some down in district court to clear up one of the cases. Again, just asking the court to consider that financial difficulty he's undergoing right now.
All right, so Mr. West has, because of circumstances, not been on the GPS tether for the last several weeks, and he has appeared. So I think he has shown willingness to appear and get this resolved. I am at this point then going to eliminate the GPS tether. The scram unit needs to continue, however.
Yes, sir.
Thank you, Judge.
Thank you, Your Honor.
All right. So, Mr. West, your next date is July 23rd at 8:15.
Sir.
Thank you, Mr. West. I'll talk to you soon, okay?
Have a good day.
Thanks.
Okay, let's see, Ms. Eaton Gordon, are you going to need a breakout session with Ms. Gessman before we begin our case?
No, Your Honor.
Okay. Let me do Mr. Skinner and then we'll get to that
Thank you, Your Honor.
This is file 24-22029-FH and 24-22031-FH, People versus Patrick Lee Skinner. We are here today for a hearing on a contempt of court in both of those cases, and we are proceeding today by video conference. Pretrial as well. I guess we've got pretrial on the underlying cases as well. First, I have the attorneys place their appearances on the record. No, I'm sorry. This is a probation violation as well as a contempt.
Case.
Yeah, I'm sorry. It's a probation violation and it's a contempt for failure to appear in the probation violation. So, Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Skinner this morning, Your Honor. At this time, Mr. Skinner wishes to enter a plea on the violation and contempt, Your Honor.
All right, Mr. Skinner, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Patrick Lee Skinner?
Yes.
Mr. Skinner, do you understand that you have a right to contest the violation of probation charge and to have a trial on that?
Yes.
Do you understand that you also have a right to contest the contempt of court charge and have a trial on that?
Yes.
Do you understand that if we had a trial, that throughout that trial you'd be presumed innocent until your guilt is proven by a preponderance of the evidence with respect to the violation of probation charge?
Yes.
And do you understand that you would be presumed innocent until your guilt is proven beyond a reasonable doubt with respect to the contempt charge?
Yes, sir.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, do you understand that you have a right to testify if you wanted to testify?
Yes, sir.
How do you plead to the charge that you violated your probation by failing to report in May and not being at the team challenge of Detroit as you said you were?
Guilty.
And how do you wish to plead to the charge that you failed to appear in court for the summons hearing on June 18th, 2025?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anyone threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
So you were originally placed on probation in this case back in May of 2025. Is that correct?
Yes, sir.
And one of the conditions of your probation was that you report to your probation officer as instructed. Is that also correct?
Yes, sir.
And
I
You
forgot the
did
date,
not-
Your Honor.
I'm
Like
sorry.
I literally, I forgot the date. Like I literally, once I found out that it was the 18th, I got arrested here on the 18th, that later that night, because I came to Adrian to turn myself in the next day to you, which was Juneteenth, and I didn't know that. And that's why I got arrested on the 18th at late that night, because I came back to Adrian to turn myself in to face it. I literally, I thought it was a later date. I thought it was supposed to be the 27th and not the 18th. And
Okay,
that's
so,
what happened.
but you did not report to your probation officer during May, is that correct?
No, I thought I was supposed to report May 27th. Oh, no, I didn't think I was supposed to report to the 27th. I really didn't, I didn't know. That was my mistake, and I can't make no excuses for that.
And
I've
at
been-
some point, you had changed your residence as well without notifying your probation officer. Is that also correct?
Yes, sir. I didn't, like I said, I don't know all the rules to probation. Frankly, I've never been on probation long enough to know the rules. I really, it's
Well,
always
one way
been.
to learn the rules is to report to your probation officer and talk about what the rules are.
Yes, sir. I
So,
know.
That's what you need to do. So we had a hearing on this summons for probation violation on June 18th, and you did not appear at that hearing. Is that correct?
Yes, sir. That's the one that I missed.
All right. I'll accept your pleas then. They've been given understandably, voluntarily, and accurately. Mr. Skinner has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for an update of the pre-sentence investigation, and I will set sentencing for July 3rd at 8:15 a.m.
Your Honor, may I be heard as to bond on this issue?
Has anything changed since the last time we discussed bond?
I'm not sure we've discussed it.
You discussed it when he
I
was
think
arrested. Go ahead.
I'm not sure. I apologize if we did. I think Mr. Skinner has a very clear idea now of when he needs to do things and how to do them. I would ask that the court give Mr. Skinner an instruction to report to probation immediately upon release and grant a PR bond in this matter until sentencing, Your Honor. This is at worst a technical violation on a very new probation, and I think Mr. Skinner just got off on the wrong foot. I'm hoping we can change that, Your Honor.
I'm filling in for Mr. Stevenson. Obviously, we would object to that. He didn't even report to go over his order of probations. Therefore, as he stated, he doesn't know the rules. We don't know where he's living or anything else, so we would ask that he remain in jail until sentencing.
I have an address for him, Judge. I didn't know the date. Like the date, I thought it was the 27th and not the 18th. I thought I had to report by the 27th.
All right. In addition to this issue, Mr. Skinner also had a contempt for failing to appear at arraignment and has had a warrant issued for failure to appear at sentencing. And so I can't trust Mr. Skinner's word when he says I'll show up at this point. So I've tried several times and got burned on it, and I'm not going to let it happen again. So the request to modify bond is denied.
Thank you, Your Honor.
All right, Mr. Skinner, you can let the officer with you know that you're done with court for today.
All right.
Okay, Ms. Eden Gordon, are you ready to proceed with Ms. Gessman?
Yes, Your Honor.
All right, this is file 24-21976-FH, People versus Gianna Isabel Gessman. We are here today for a status conference. The court has previously ordered a psychological evaluation for Ms. Gessman. Let me, I guess, first ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Evie McClure, map the people.
Nancy Eaton Gordon, appearing by special appearance to the Public Defender's Office on behalf of Ms. Gessman.
Okay, and Ms. Eaton Gordon, where do we stand with Ms. Gessman's situation today?
Well, Your Honor, first you had asked at the last hearing for me to check with Bert Castleberry regarding Ms. Gessman's statement and want to have counsel reassigned. I did so, and per Mr. Castleberry, he does not currently have the authority to reassign counsel. If Ms. Gessman wishes to make a formal motion to terminate me as her counsel, and that you, Your Honor, were to find a basis to grant said motion, only at that point could he look into reassignment or consider it. I know at last hearing she did make an oral motion, but as I recall, Your Honor stated there wasn't a valid basis for you to grant that at that time. So I'm not sure if she wishes to remake said motion or to have a formal motion presented. Before I continue, I guess I want to ask the court what they would like to do on that issue.
All right. Well, let me ask first, Ms. McClure, is there anything that we need to address from the people's side?
I guess on the issue of counsel, I don't know that I have much standing to make any sort of argument one way or the other. I do think that we've had this competency issue outstanding, and I don't know that Ms. Gessman can make decisions about her case without having that issue resolved. I think in the past she was found competent with medication, but then became unmedicated to become not competent again, and then had issues appearing. So if she's currently medicated and competent, then I guess we can ask her opinion on where she stands on counsel. But I also believe this is maybe her second or third attorney, and I do think we're kind of running into some issues with that.
Can I say something real quick? If it doesn't object to anything that you're saying, that's objectifiable. Well, they put me on medication at the last jail I was at because I had a court hearing in May and I didn't make it because I had a warrant out of Woodcut, Ohio. And so I was in Woodcut, Ohio, and they said that I had to transfer my transcripts and my paperwork from here to there. So I freaking filed for doing that, and then they said that I had to do something else too. And I was there for 4 months, and then I guess they didn't get a hold of my this piece. And then I came here and I was going to turn myself in, and then I was at my uncle's, and they said that I had to go to jail, and so I went to jail, and then they said that I missed my court hearing or whatever, so I had a bench hearing request out of Adrian or whatever for the uttering and publishing, but I already did, I think I did 4 months or a year or something like that for my uttering and publishing, which I don't care about because I did my time, but they're saying that I have to go and reestablish what I had been doing.
Gianna, we're going to get to that part in a minute. We're just here on the contempt today, so let the judge go forward, okay?
I'm sorry. It's just, I was just trying to tell him like a timeline of where I was, a scattered timeline of where I was.
Get to that, I understand. Just let the judge go forward. I know he's very busy today.
All right, I'm sorry. You can understand. Sorry.
All right, I don't know at this point. I mean, we have a pending order for psychological evaluation. And so I don't, which means there's a question as to Ms. Gessman's competency. And so I don't know that it's appropriate for me to inquire from her as to whether she wants to make a motion, because we don't know whether she has the ability from the evaluation standpoint to do so. So
Yes,
what
sure.
I would do is hold that request at this point until we have the results of the psychological evaluation.
Thank you, Your Honor. That's what I figured you may go towards, but that's why I stopped at that moment. The only other update I would have at this point then is we did submit an order for the competency evaluation on or about June 6th. We believe the court signed it the same date and submitted it shortly thereafter, but we have heard no updates on status. I can say I spoke with a fellow counsel who had requested one through this honorable court about 3 to 4 weeks before my request went in, and he is also still waiting. So it's our understanding there is still a backlog for these type of examinations with the hospitals that need to perform them. So I have not received any further update at this point.
So typically, once an order is signed, we do a 90-day review and give the forensic center that review date so they know what their deadline is.
I'm currently on meds right now. I'm on Zyprexa. They have me on Zyprexa that they gave me, and they changed my meds. And the last time I was in the mental hospital from Adrian, they took me to West Plains, and they let me out after 4 months and said that I was okay.
Yep.
So
Gianna,
if that's what you're looking for, I was in West Plains and they stated that I was okay. So when they stated that, I was like, okay, then if that was still fucking hot, then that was what pot I was in.
Yeah, Gianna, and we're working on that right now. So the court's just got to get things in order. Your Honor, that's the only update I have, unless Ms. McClure has any further additions at this time. We would agree that it seems very appropriate to wait for the examination and set the 90 days out, so we can go from there.
So what does that mean? Like I'll be going to a different facility or something, or
just wait just a moment.
All right, so it was 2 weeks ago that the court signed the order for competency examination. So running 90 days from that date would take us to first or second week of September. So we could set it for September 3rd or September 10th.
I can do either of those dates, so I would defer to the court and or Phoebe on this one.
We can do the third date, but with the understanding that if we get a competency opinion back sooner, we will have to get her in within so many days.
Yeah, the court's required once we get the report to hold the hearing within 5 days. So obviously
But I'm good with it.
September
3rd.
September 3rd at 8:15. Again, with the understanding that if we receive the report that a hearing will be scheduled within 5 days of receipt of the report.
Thank you.
All right. Anything else we need to address today, Ms. Eaton-Gordon?
Not that I'm aware of, Your Honor. I defer to Mr. McClure in case she has anything to address.
Nothing on behalf of the people, thank you.
All right, Ms. Gessman, you can let the officer with you know that you are done with court for
Thank
today.
you.
Thank you, Your Honor. Thank you, Ms.
Ms.
McClure.
Eaton-Gordon. Okay, Ms. Underwood, on Mr. Broughton, they were apparently logged in right at 8:15, but logged out because I didn't call it right at 8:15. So we're gonna have to pick another date for that one.
Okay, Your Honor.
How about July 16th?
Did you say 16th?
Yes.
Okay, Your Honor.
Mr. Murphy, I have Ms. Allen here. Are you gonna need to speak to her?
If I could, please, Your Honor.
Yes. Ms. Allen, I'm going to put you in a breakout session with Mr. Murphy, if you give me just a second.
Okay, thank you, Your Honor.
Oh, I forgot.
Your Honor, I'm Mr. Broughton. Would you like me to do the stipend adjournment with Mr. Sneed's permission?
Yes, I would appreciate that very much. Thank you.
And Mr. Sneed, I presume, will do the rest.
Yes, well,
Correct.
actually, you do with a Zoom read. Okay.
Thank you, Your Honor.
Okay, let's see. Mr. Malero, are you ready with Mr. Smith?
Yes, Your Honor, I'm ready.
Okay, this is file 25-22247-FH, People versus Dustin Wayne Smith. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Ms. McClure.
E.V. McClure, may have the people.
Salvatore Malero on behalf of Dustin Smith.
And Mr. Malero, where are we with Mr. Smith's case today?
Your Honor, we're going to ask to adjourn the matter. The basis for this is twofold. One, we've ordered a transcript of the preliminary exam. I think we put that in sometime in May. And the second reason is we're trying to investigate a potential witness, and we've had trouble connecting with that person. That's the reason for our request.
Ms. McClure, is there anything we need to address from the people's side?
I have no objection to the adjournment, and I just wanted to inquire of Mr. Malaro if I've given him the new offer since the preliminary exam. I did not recall if I've done that. If I haven't, I will send an email with it after today.
Yeah, if you could do that, and then I'll go talk to Mr. Smith about it.
Okay.
But I don't. You may have sent something, but I don't recall it.
I didn't put in my note that I sent it, so I wanted to double check.
Okay, no problem.
Okay, let's set it then for July 23rd at 8:15.
Your Honor, I'm not available that week. So I'd be available on the
Okay.
16th, I think, or the week after.
I am not available on the 30th, so we'd be looking at the 16th or August 6th.
I would prefer the 16th of July.
Okay, we'll do July 16 at 8:15.
Thank you, Judge.
Sir Malera, would you prepare that stipulation in order, please?
I will prepare the stipulation order at your request, Your Honor.
Thank you. And Mr. Smith, you can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
Thank you, Judge. Thank you, Ms. McClure.
Thank you. Judge, I'm gonna go ahead and log out. I believe that was my last case with you this morning.
Okay, thank you. All right, and Mr. Dagger-Margosian, I believe I have Mr. Nelson here. Are you going to need a breakout session?
No, thank you.
Mr. Nelson, are you there? Okay, so I have someone logged in with the screen name of Coach Nelson, who I assume would be Milo Nelson, but the audio on that device is not connected at the moment and the camera is not on, so we're not able to proceed with that right now. I will send a chat message with instructions on connecting audio. Mr. Millar, I don't have Ruth Taylor logged in. And Mr. Fry, I don't have Mr. Watson Clark logged in unless he is in your office with you.
Judge, I just sent you a message on Miss Taylor. And I'm currently providing her our fax number so she can verify her situation.
And Your Honor, Anthony Watson Clark is in my office, so we're ready whenever the court's ready on him.
All right, Mr. Nelson, are you able to hear me? Can you hear me, Mr. Nelson? I'm not getting any audio from him. I see that he said something. Mr. Nelson, can you try that again? Are you able to hear me? Okay, there's apparently something wrong with your device that's not, we're not getting any audio from you. What I'll ask you to do, Mr. Nelson, sometimes it helps if you leave the meeting and then log back in. And in the meantime, we will do Mr. Watson Clark's case. So this is file 25-22230. FH People versus Anthony Wayne Watson Clark. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bandit?
Alex Bayoneto for the people.
Brian Fry, appearing for Anthony Watson Clark.
All right, and Mr. Fry, where do we stand with Mr. Watson Clark's case today?
Yes, Senator, we have been in discussions with the prosecuting attorney regarding a potential resolution. I think there's maybe one or two additional conversations we had before a final or a decision can be made on how to proceed. So we'd ask for a short adjournment, and I think at that point in time we'll have an answer on where we're going to go with this case.
All right, Mr. Bayoneto, anything to address from the people's side?
No, Your Honor, I have no objection to an adjournment.
Okay, let's go with July 23rd at 8:15 a.m.
Your Honor, I'm actually out of the office on that day. Can we have a different day?
About July 16th at 8:15.
That would work for me.
Okay. Mr. Fry, would you do that stipulation in order for the adjournment?
Yes, I can do that, Your Honor. Mr. Bayoneto, can I sign your name with?
You can, thank you.
Thank you.
Okay, we are all set for today then. Mr. Fry, you can go ahead and log out.
Thank you.
Okay, we have Mr. Nelson back. Mr. Nelson, I'm going to send you a request to unmute. Okay, Mr. Nelson, are you able to hear me? Still not getting any audio from Mr. Nelson. Mr. Nelson, if you can hear me, can you just shake your head yes? So he can hear us. I don't know why we're not able to hear him. I guess what I'll do is call the case and do what we're able to do. So this is file 25-22150-FH People versus Milo Edwin Nelson. Here today for a pretrial conference and proceeding today by video conference. I would note for the record that Mr. Nelson is present by Zoom. He is able to hear us. We are not able to hear him due to some technical problems. So first, let me have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Mr. Nelson.
And Mr. Dagger Margosian, where do we stand with Mr. Nelson's case today?
Your Honor, I've spoken with Mr. Nelson extensively about this case. At this time, I'd like to ask the court to set this for a jury trial, please.
All right, and how many days do you think will be necessary? I guess let me ask Mr. Sneed first. Mr. Sneed, what are your thoughts on length of time for trial?
1 to 2 days, Your Honor.
Do you agree with that, Mr. Dagger Margosian?
That sounds right, Your Honor. Thank you.
Okay. Ms. Clark, could you give us a 2-day jury trial date, please?
Wednesday, September 10th at 10:30 and Thursday, September 11th at 9.
I'm already scheduled in trial and Judge Enslin on that date, Your Honor.
Thursday, September 18th at 9 and Friday, September 19th at 9.
That works. Thank you.
That's fine. Thank you.
Okay, so let's do a final pretrial then on September 8th. At 8:15, and then trial on September 18th at 9 and 19th. And the court will send out a scheduling order with those dates.
Thank you, Your Honor.
All right, thank you then. Mr. Nelson, you are all set for today. You can go ahead and log out. All right, Mr. Murphy, are you ready to proceed with Ms. Allen?
Yes, Your Honor.
All right, this is file 25-21155-FH and 25-22156-FH. People versus Jennifer Lynn Allen. We are here today for a pretrial hearing in the 22155 case and a show cause hearing in the 22 pretrial and a show cause in the 22155 case, a pretrial also with a pending contempt of court in the 22156 case. First, I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing back from Ms. Allen.
And Miss, you are Jennifer Lynn Allen, correct?
Yes, Your Honor. Sorry, I'm plugging my phone in.
Ms. Allen, have you received a copy of the motion affidavit in order to show cause?
I think so. Yes, Your Honor.
Oh, actually, the original appearance on that was back on, that was last week on July 8th or June 18th. Give me just a second. So Ms. Allen was arraigned on that show cause last week and entered a not guilty plea, so we don't need to go through that. Mr. Murphy, where do we stand with these cases today then?
Your Honor, I just wanted to clarify, because I did see in the Register of Action online that there was an outstanding or an active warrant on one of these files. I just wanted to make sure that was cleared up this morning, that it was from that show cause that she appeared on. There wasn't anything new that had to be arraigned on. And with that, I think that was clarified by the court just now.
Hang on, Mr. Murphy. because I think that does allege some new behavior.
And I apologize, Your Honor, but I don't have any paperwork about any other behavior other than what was addressed last week.
And Judge, since that June 18th court date, she has missed 3 more drug tests.
Well, Mr. Murphy, I just dropped that warrant into the chat. So the warrant alleges that the GPS tether's been cut off and some additional missed drug tests. I'm sorry, not cut off, but turned off.
Judge, that was turned off on the 11th. I did receive verification that that GPS was reactivated on 6/13 as payment was made.
Okay, so if that's the case, then it's just an issue of the missed drug tests.
And that would be for the missed tests on the May 19th, 22nd, 23rd, and 28th, or the ones after that? I'm sorry, Mr. Coase, I forgot.
It would be May 19th through June 23rd and continuing. I don't think she's done any testing since May 19th.
And actually, Judge, she did show on May 19th that did not have money for the test, so a test was not done. The last test that she actually went and did was on May 16th.
All right, what I am going to require at this point is that Ms. Allen come into the courthouse today and be tested. And then I will decide how to proceed when I have the results of the test. You are muted, Mr. Post. Mr. Coast, if you're speaking to us, your device is muted.
Jennifer, come to the courthouse today before noon. Come up to the 3rd floor. Go over to the clerk's office. Let them know that you're there to see me.
Okay.
All right, so you need to be here by noon today.
Okay.
Your Honor, do we want to adjourn the pretrial till this afternoon to see what the results of that are, or do we want to proceed with the pretrial right now?
I would adjourn this then until let's go with 1:30 p.m. We'll have the results of the test at that point.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, so I think we're all set then for the moment. And let's see, Mr. Malero, were you able to get any further information on Ms. Taylor?
Your Honor, I did speak to her and informed her that I gave her our fax number for her to send verification. I told her to have that by the end of the day.
Okay, let me call the case so we can make a record of it. So this file 25-22-103-FH, People versus Ruth Ann Taylor. We are here today for a pretrial conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Salvatore Malero on behalf of Ruth Taylor.
And Mr. Malero, we have been having some discussions about Ms. Taylor's presence today. Do you just want to restate for the record what the situation is?
Yes, Your Honor. Ms. Taylor has regularly maintained contact with me, even coming in several times for appointments. She had a message this morning that she was in the U of M hospital, provided a number for which I called. She answered the phone. I had to cut her off at one point because she called Mr. Smith's case. I called her back, informed her that I needed some kind of written verification from the hospital that she was there, gave her our fax number, and told her I said we need to have that by the end of the day. So based on that, I would ask to adjourn this matter. I know it's been hanging out there for a little while, but given the fact that she's in the hospital, I think that's an appropriate request.
Okay, Mr. Bayoneto, anything from the people's side?
No, Your Honor, I would defer to the court's discretion.
So what I'll do is adjourn this to July 23rd at 8:15 a.m. This is, as you said, Mr. Malero, I think last time I indicated that I would set this for trial if it wouldn't resolve as of today. Obviously, that's not possible due to circumstances. So I would, on July 23rd, be setting it for trial if there hasn't been a resolution at that point.
Understood, Your Honor. Thank you.
Okay. And would you do that stipulation in order?
Yes, I will do that, Your Honor.
Okay.
Thank you,
I think
Judge.
that's all I have with you this morning, Your Honor. Have a good day.
I think we are all set for the morning then. Thank you.
Thank you, Judge. Have a good day.